All right, joining us for more on this is the NPA spokesperson, Mthunzi Mhaga. Mr. Mhaga, good afternoon. Thank you very much for joining us.
Good afternoon, and good afternoon to listeners, and thanks for having us.
No, it's a pleasure to have you with us. So you've released a statement condemning what has happened, which is the leaking of Mr. Mthunzi's affidavit. Talk to us about this, perhaps just detailing the position of the NPA on this matter.
Look, this is quite disheartening and disturbing because it has the potential to undermine the proper administration of justice. It also has the potential to place at risk the lives of people mentioned in the affidavit. Secondly, the investigating officers and the team, as well as the prosecution team that is seized with the matter. It also has the potential to compromise the pending prosecution against the other accused persons, because you know that one of them has already been convicted and sentenced. Now, we have instructed, that is the National Director of Public Prosecutions, has instructed the Director of Public Prosecutions in Pretoria, Advocate Mthunzi, to conduct a comprehensive investigation together with the DPCI in order to establish who is responsible for the leak and what is it that can be done to deal with that person decisively. We're also looking at legal options, whether it is permissible for the media to publish information that relates to cases that has been leaked to them. So it's a two-pronged approach. We're quite disturbed because we want a situation where cases that were seized with, especially those that are high profile and complex, that involve politically exposed individuals, to be ventilated in a proper forum, which is the court of law, not in the public domain like in the media and social media and the likes.
So essentially what you're saying is that what has happened here is that even the suspects themselves have been forewarned as to what exactly is happening.
I will adopt a generic response to your question without talking specifically about this case. The compromise relates to the pending prosecution as well as any pending investigation process that may be underway. Because when you expose information that has been unlawfully obtained, it has that detriment.
I want us to speak about the element of transparency, and then maybe you can be the one that explains at length what exactly this means. Because on Wednesday, when there was the sentencing of Mthunzi, we spoke to Colonel Katlego Mohale from the Hawks, and when asking around the details of the plea agreement, she was skirting past that. We really didn't get anything. But for the ordinary viewer at home, there could have possibly been of the view that here we've got an evasive law enforcement, and if we are victims of the VBS looting, we don't know why a significant amount of years that Mr. Mthunzi could have possibly gotten if he was sentenced, 400 as it was stated, was shaved off and he got 15 years.
Let me first
just explain to us, for just that ordinary citizen who would have thought we have no further information, why they got to 15 years if they said that he was perhaps the mastermind of the looting of VBS.
The important things is that the basis of the plea and sentence agreement is in terms of a section 105A of the Criminal Procedure Act, which makes provision for the NPA or the accused person to get into an agreement on the conviction and sentencing procedures that would be applicable in a particular case. And there's a wide range of consultation that touches on the complainant, the investigating officer, the victims, and all of that. All that process was undertaken in respect of Mr. Mthunzi. Now, when we talk about the sentence, the judge sentenced him to 495 years, but ordered same to run concurrently and effectively is 15 years. And of importance is that 15 years is a direct term of imprisonment where a person goes and serves a sentence inside a correctional facility. It's not a non-custodial sentence. It's not correctional supervision. It's not a suspended sentence. Therefore, we consider the sentence to be appropriate. Coming back to the question of what Colonel Mohale did, was that she did not want to compromise a pending prosecution in respect of other accused persons, because remember, the matter is not over. This is but one of the ongoing prosecution strategy of the NPA to hold those responsible for VBS matter accountable. Mr. Mthunzi is one of them in his case, and the rest will follow when the matter comes up on the 22nd of July for a pre-trial conference where all outstanding and preliminary issues will be resolved for a matter to go to trial, so that all these issues that are now now ventilated in a wrong and improper forum, that is the media, are ventilated in a proper competent court of law.
And now that the affidavit is in the public domain, unfortunately so, but now that it is it illegal to continue to disseminate this information?
That is but one of the legal options that we want to explore in order to hold those that continue to publish it accountable if the law prohibits such to be done. It's a two-pronged approach, which is one, the investigation of who leaked it and hold him accountable for that. Secondly, to explore a possibility of whether legal is permissible when you receive a leaked information to further disseminate it or publish it.
But how difficult is it for the NPA to balance the public interests against some of these very sensitive cases that you're seized with? Because I know even with you as the NPA, including the Hawks, there's always pressure because this was a very sad case, what happened to especially a number of grandmothers.
Vulnerable.
Yes.
And the poor.
They save their money, and to wake up and go to a bank and find out that the bank essentially is closed, you're not getting your money. You, even as the NPA, would feel the need to keep those communities abreast of some of the developments. So how difficult is it to balance these interests?
It is not a difficult one, because those parties that are supposed to be privy to information that will be shared between parties have that information. Secondly, those affected and victims of the crimes that were committed are kept abreast of what is happening. That's why I'm saying it's a balancing act that is easy to manage. It is not the first time that we have a high-profile complex case like this. We've prosecuted high-profile cases in the past. We've sent people to jail in circumstances where no one thought that the NPA could succeed in those cases. So it's a balancing act that is easy because we're trained in doing so. It's just that we're disappointed by men who lack or women who lack integrity and get into unscrupulous agendas of leaking information for their own benefit, which I don't know what it is.
But now that we are here, are you confident of a successful conviction? I mean, just based on what you have, or even that is difficult to comment on?
I always shy away from talking about confidence and watertight cases, strength of the state case and all of that. Because what we have will place it before a judge, and all those issues will be ventilated before a proper court of law. Let's allow the law to take its course. Let's allow the wheels of justice to get into motion. They have partially done so in respect of the 105A agreement, and they will do so from the 22nd of July onwards.
All right. There was another high-profile case this week. We had the Esidimeni inquest judgment. Very important one. The ball is now in your court. We've spoken to NGOs who are saying they're all awaiting your decision on this. What is the next step for the NPA post the release of that judgment?
Currently, the Director of Public Prosecutions in Pretoria, Advocate Mthunzi Mhaga, is seized with the matter and his prosecution team. They will study that judgment and the inquest and any additional information that comes their way and make a determination whether there's relevant and admissible evidence that can sustain a prosecution decision that will be made. So we're at a stage where they're studying the judgment and will make a decision. But if when they go through evidence that is placed before them, they are of the view that there's additional investigations to be conducted, they will do so. It should be noted, Fundo, that an inquest, by its nature, is not necessarily equating to a trial-ready case that you can take to court. Criminal trial unfolds, a person is convicted. You have
similar to what we saw with the commission.
Yes, yes. And,
so it's more inquisitorial.
Exactly. So of importance is that the NPA must be given space and time to consider what is before them and make a determination if a prosecution should be mounted against those whose names there are adverse findings that have been made.
All right. Mr. Mhaga, thank you very much for your time. That's the NPA spokesperson, Mthunzi Mhaga, speaking to us on a number of legal cases currently underway.